Well, there are some people in Hollywood tonight who are probably not too happy. That's because a judge in New York has ruled that internet searches and downloads and other activities that take place from your computer do not automatically mean you are the person behind them. An important point when weighing illegal downloading cases. In other words, an IP address is not a person. Now, this particular case involved the illegal downloading of an adult film, and the ruling has made several internet privacy advocates quite happy tonight. Mitch Stoltz is an attorney with the Electronic Frontier Foundation. And Mitch, let's just talk about what changes after this ruling.
Sure. This is actually one of a number of rulings around the country that have said similar things. This is the background. Your viewers should know the background to this. Since about 2008, the plaintiffs' lawyers have been suing so anywhere between 25 and 5,000 people in single lawsuits, accusing them of downloading copyrighted movies. They're usually either independent films or pornography films. And the lawyers who are doing this, they really don't care who's doing the infringing. They just want to get as many settlements out of this process as they can, and they will usually settle for less than the cost of hiring a lawyer.
Yeah, it seems to me there's been a whole business built on attorneys and their assistants kind of trolling the internet, looking for people who are infringing, who are breaking copyright laws, and then what they do is they, get as many names as possible and file lawsuits en masse. I mean, what do those people do next when they try to, now that this is yet another ruling in a pile of many, how will they now find people who break copyright laws?
Unfortunately, what they'll probably do is just file their lawsuits in front of other judges who are more sympathetic to them. That's the pattern that we've seen. Now, there are increasingly fewer of those judges.
Interesting. And I know the judge in this case in New York, Judge Gary Brown, said that copyright infringement cases that only provide an IP address as evidence are a, quote, waste of judicial resources. What do you think he meant by that?
I think it's a recognition that suits based only on that. So these copyright trolls have an investigator who supposedly goes out and collects a list of IP addresses of computers that he witnessed downloading a copyrighted movie. But as you said, and as the judge said, that doesn't identify a person. That just identifies a computer, and maybe not even that. We don't actually know how this list of IP addresses is gathered, and no judge has really ever looked into how that method works. If that's all you have to go on, then it's just so likely that you're targeting an innocent person that I think that's what makes it a waste of judicial resources.
You know, when we talk about all of these companies who are probably, bummed out by this ruling, the Motion Picture Association of America, some of these larger corporations that, by the way, have a lot of lobbyists here in Washington, D.C., it seems to me the way things tend to work here is this is not going to do that much to stop things. I'm wondering what your concerns are in terms of what comes next for some of these larger corporations trying to make sure that movies and music are harder and harder to download.
It's interesting you mentioned MPAA and so on, that the large copyright holders organizations, the large entertainment companies, they pretty much abandoned this strategy back in about 2008, this strategy of suing people in large groups for downloading on the internet.
Why do you think it is that they abandoned that strategy?
Because they were essentially suing their customers and potential customers, which is just not a smart way to do business, and I think they realized that. In the process of doing that, though, they created a lot of the legal precedents that the copyright trolls, who were basically people with no reputation to protect, have taken advantage of now. The entertainment industries, I think they much prefer to deal with the problem as they see it by targeting the middlemen, the internet sites, the internet providers, the payment processors, the advertising networks. So somebody with one address rather than 5,000, who they can go after. That's been their strategy in the past few years.
And of course, this case that we're talking about, the illegal downloading of an adult film and this ruling, this is just one of so many things happening every single day, Mitch, regarding internet privacy, internet freedoms. I know the Electronic Frontier Foundation has been doing really a massive amount of work on trying to protect some of those freedoms. What is your concern now? What's the focal point? A small victory in this case, of course, but I'm sure there are quite other larger concerns as well.
Oh, there are too many to list, so I'll just mention two. The various cybersecurity bills in Congress right now that would really potentially deal a blow to privacy on the internet. We have a lot of concern about those, and we're working carefully with other organizations to try and improve them. And on the copyright front, what we're really hoping to see, and what hasn't happened yet with regard to these copyright trolls, is an opinion by an appeals court to say, what are the standards for suing individuals for downloading from BitTorrent or downloading copyrighted movies? What's the way that you can do that legally and ethically and preserve people's rights and preserve the idea that you're presumed innocent?
I mean, we are at such an interesting time right now, it seems to me. We've had the internet for, I mean, regular people have used it at least for the last, 20 or so years. But now the laws and some of the regulations are starting to catch up with the technology. And really, this is a time, you mentioned some of the legislation. We just saw the Cyber Intelligence Security Act, Privacy Act last week, 1 week ago today. CISPA pass in the U.S. House of Representatives. The Senate is working on a similar bill. It just seems to me that everything's sort of catching up right now, and they're really trying to clamp down on what is and is not allowed, because for so many years we haven't had those rules. Do you think that there is a fair middle ground, that there's going to be a good way to go about doing this?
Yeah, I think that there's a different solution for different problems, and these are a bunch of different problems. I think the reason why we're seeing all this at once is because as more and more people use the internet for their everyday tasks, these things, be it privacy, file sharing, getting sort of drawn into the legal process, but all of these things are starting to really hit people where they live and in their daily activities. This isn't just a realm of corporations anymore.
That's true, and people are starting to take notice. I appreciate you talking with us this evening. Mitch Stoltz, staff attorney at the Electronic Frontier Foundation.
Thank you.